Brooke Bryant, Supervising Attorney of the Community Engagement Unit at Legal Aid of Southeastern Pennsylvania. I'm going to spend some time today talking about the different types of relief available for folks with criminal records. So we'll talk about expungements, we'll talk about limited access or having the court seal a record so it's not publicly available. We'll also talk about pardons and the pardon process, as well as what types of records are eligible to ask for a pardon. At the very end, we'll spend a little bit of time talking about employment protections for people who have records and maybe those records aren't yet eligible to be expunged or sealed or pardoned so that folks can try and be working in the meantime. If you have any questions or you're interested in seeing if Legal Aid of Southeastern Pennsylvania can help you clear up your record, I invite you to contact our intake department at any time. You can apply on our website 24 hours a day, 7 days a week at www.lasp.org. That's L as in legal, A as in aid, S as in Southeastern, P as in Pennsylvania.org. And the website is listed on the handout that should be on your screen now. You can also call our intake department, which is open and staffed by trained attorneys and paralegals to answer your questions and open up files to pass along to attorneys. The intake hotline is 1-877-429-5994. And again, that's listed on the handout for you. Legal Aid of Southeastern Pennsylvania, as you may have already heard, is a nonprofit. We provide free attorneys to income eligible clients who have civil legal needs, which means if you need an attorney to help you with a landlord-tenant case or with family law, that's us. If you need help clearing up a criminal record that's old, it's closed, it's resolved, that's work we do as well. However, let me caution you that if you have an open and active case with pending charges, that's not legal aid, that's the public defender's office for the county where the charges are being brought. If you have any questions or uncertainty, if you call our intake department, we'll certainly point you in the right direction. Okay, so without further ado, I want to start talking about the different types of relief available. You should see before you the second page of the handout right now. And before I get into the nitty-gritty about what types of records are eligible, I want to make sure we're all really clear about what the difference is between having a record that's been expunged versus sealed versus pardoned. So an expungement is the most thorough type of relief available. It's great. If a record is expunged, it is gone. It is destroyed. No one has access to that information anymore, so it's not available even to the court system or to the police. As you can imagine, because it's such great and thorough relief, it's only available for a wide subset of types of records. So you may find you have a record that's not eligible to be expunged, in which case you would want to find out whether it's eligible to be sealed. If a record is sealed, it is what it sounds like, right? It still exists, but it's not publicly available to everyone. So it gets a little bit complicated who has access to it, but painting with a broad brush, it's generally still available to law enforcement. It's going to be available to the district attorney's office. It's going to be available to police. It may still come up on a background check if you're applying for a job where the employer specifically has to do a federal background check because they're required to under federal law. Then it may appear in that circumstance. You can imagine employers like, let's say you're applying to work in finance or at a school and you have a record that's been sealed for something that's directly related. So if you're trying to work in finance and you have a sealed conviction for, a fraudulent wire transfer or bad checks or something like that, credit card fraud, that may still appear on that background check. But by and large, most employers do not have access to information once it's been sealed. So that means a publicly available background check wouldn't show anything. There is a state court website that lists criminal records. Sealed records do not appear on that website. Landlords don't have access to sealed records. Schools, by and large, do not have access to sealed records. And sealed records can't be held against you when applying for most jobs or when applying for most professional licenses. So if you want to get a license to practice as a nurse or a truck driver or a cosmetologist, any number of fields, a doctor or an attorney, all require professional licenses, and most of those licensing agencies don't have access to sealed records, or if they do, aren't allowed to consider them. These don't have access to sealed records, or if they do, aren't allowed to consider them. So sealed records are great. It is a heck of a lot better than having something just be publicly available, but it's not quite the same as something being expunged. So I just want to make sure we're clear about that distinction. The third type of relief available is a pardon. So I think often people think about pardons because we hear about them on the federal level where, pardons get granted by the president. Pennsylvania has an equivalent, which goes through the statewide Board of Pardons. They make a recommendation to the governor, who ultimately decides whether or not to pardon a record. Before we talk in more detail about that process, I just want to make sure we're all clear that under the current law, if a pardon is granted, it does nothing to change the public availability of that record. So if a pardon is granted and someone does a background check, the fact that you were arrested will still appear. The charges will still appear. The only thing that changes is that, the outcome of the case might say, instead of saying guilty or guilty plea or conviction, it might say pardoned by the governor, which is something, but people who aren't convicted don't go through the pardon process. They don't need to. So it still kind of lets the cat out of the bag about the fact that there was a conviction. What the pardon really does is it changes your eligibility for expungement. So if a pardon is granted, it takes a record that couldn't have been expunged and it makes it eligible to be expunged. After you go through the expungement process, then the record check would come back clean, clear, as if nothing had ever happened and you had never had any arrests or convictions in the first place. So it's just important to know that it's a two-step process to clear the record. First the pardon, then the expungement. Okay, so hopefully we're clear now on the difference between expungement and sealing and pardon. And now I'm going to get into some more specifics about what types of records are eligible for each. So any non-conviction, you can petition the court to expunge that record. So what do I mean by that? If someone is charged, they're accused by the police or the district attorney's office of doing something, but then when they go to court, those charges are withdrawn or dismissed, nol prost, which means not prosecuted. If the charges are dropped, then you can expunge them. Non-conviction charges in Pennsylvania, if all the charges are non-convictions on the whole case, they are being automatically sealed at this point, but sealed is not the same thing as expungement, right? So if you want the most thorough type of relief available and you have charges that were brought against you but were dropped, you weren't convicted of anything on that case, you can absolutely, it is your right to go through the expungement process and try and have that record cleared entirely. In addition to charges that are dropped, there are also certain diversionary programs, which at the end of that process, if you successfully complete everything, it's as if the charges are all withdrawn. Because there is no conviction, you're also eligible to ask the court to expunge that record as well. Each county in Pennsylvania tends to have slightly different diversionary programs. The two that you see most frequently in the 4 counties where I work, which is Bucks County, Chester County, Delaware County, and Montgomery County. The 2 most common that you see are ARD, which stands for Accelerated Rehabilitative Disposition, or Section 17 probation, which is specifically for drug possession. Both programs generally require the person to be on probation for some amount of time. Sometimes it's 6 months, sometimes it's all the way up to 2 years. Often there is a community service requirement. There's almost always a financial obligation that has to be satisfied. So you have to pay court fines and costs. Sometimes there's restitution. And at the end of that process, if you jump through all the hoops you have to jump through, you complete every requirement. If you successfully complete the program, like I said, you're able to petition to have that record expunged. At this point, I'm giving this presentation in July of 2020. Certain counties are automatically expunging ARDs, but in the 4 county areas where I practice, 3 of the 4, you have to petition and go through the process to have that record expunged. It does not happen automatically. If you aren't sure if your record's been expunged or not, I invite you to call our intake department, and we can help figure that out for you. In addition to all of those, which are non-convictions, Pennsylvania has 3 different tiers of criminal convictions. Unlike many states, which only have felonies and misdemeanors, Pennsylvania has a 3rd lower tier. They're called summary offenses. And summary offense convictions can be expunged, but not immediately. So if the charges are dropped or you complete your ARD, there's no wait time. You can ask the court for the expungement immediately. As soon as you satisfy your obligations, as soon as the charges are dismissed, you can ask for the expungement. Summary convictions, the first time we're talking about a conviction. And so unsurprisingly, it is not the same thing, unfortunately. Summary convictions, you can ask the court to expunge them, but you have to wait 5 years after the disposition day. So the day you enter the guilty plea or a judge finds you guilty, you have to wait 5 years before you can get the expungement. And during that 5 years, you cannot have any new arrests, no new charges, no new convictions. If you do, that new case will reset your 5-year clock. So if I had a summary offense conviction for retail theft in 2011, and then in 2015, I was arrested and I was convicted for another summary offense. As long as I had nothing from 2015 to today, 2020, I will have had the 5 years that I need, and I can go ahead and petition to expunge both cases at once. However, if I had a summary offense conviction in 2015 and then in 2017 I was charged with something again, that 2017 case resets my 5-year wait from the 2015, and so I would have to wait until 2022, 5 years after the 2017 case, before I could ask to expunge the summary from 2015. Okay, so that is expungement of summary offense convictions. If you aren't sure if your record is for a summary, a misdemeanor, or a felony, you can look up the record and be sure. But just to give you a couple of ideas, I can tell you what some common summary offenses are. Things like disorderly conduct is often, although not always, a summary offense. Harassment is also often, but not always, a summary offense. Someone's first offense for retail theft, if what was allegedly stolen was worth less than $150, is a summary offense. Now, if you have multiple retail theft convictions, sometimes they ratchet up. So the first one might be a summary, and then after that a misdemeanor, and then it can go all the way up to a felony, depending on how many and the value of the items at issue. So you just want to check your record to be sure. Trespass is also something that can be anything from a summary all the way up to a felony, depending on where you were trespassing, right? Trying to break on to the Pentagon is trespass, but it's not going to be a summary. So you just need to look at the records to be certain. For misdemeanor and felony convictions, there are 3 options to try and expunge a misdemeanor or a felony conviction, but I want to warn you that they're all very restrictive. So to expunge a misdemeanor or a felony convictions, either you have to wait until you're at least 70 years old, and also the record is at least 10 years old with no new convictions or arrests during that 10-year period. Now, I'm not saying wait 10 years. I'm saying wait until you're 60. Don't have any new arrest convictions for 10 years, and then at 70, you can ask the court to expunge the misdemeanor or felony conviction. Now, that's a good option for some people. I've certainly worked with clients who were trying to expunge convictions because they, in their retirement, were looking for a part-time job, or they were trying to get into subsidized senior housing, and their very old record was a problem for them. But most people want to clear their records in their working years, and most people hope to be retired by the time they're 70. So, we're looking for relief sooner. Unfortunately, there is really only one option to be able to fully expunge a misdemeanor or felony conviction sooner, which is that you first get a pardon. And we'll talk more about the pardon process in a few minutes. I did mention that there were 3 ways to clear misdemeanor or felony convictions, so I'm going to mention the third one, although I hope that it will not be applying to anyone watching this, which is 3 years after someone dies, their family or whoever is still carrying on their memory could potentially ask the court to expunge that record for the sake of their loved one's posterity. Again, it's not why most people are trying to clear their records, so I'm just going to move on. Before we get into the pardon process, I want to talk about what types of records are eligible to be sealed. It gets very complicated very quickly, so I'll try and break it down. But again, if you have questions about this, I invite you to contact Legal Aid's intake department. So some records are sealed automatically in Pennsylvania without you having to do anything. If you aren't sure if your record has been sealed, you can order a background check on yourself and see what comes up. You can also go to the state court system's website, which is ujsportal.pa.us. And if you go there and you put in, your case information and nothing comes up, then it's very likely it's been sealed. So things that are sealed automatically without you needing to do anything, as I mentioned already, non-convictions are automatically sealed after 60 days. Summary convictions are automatically sealed after 10 years with no new misdemeanor or felony convictions. And then many, although not all, low-level, nonviolent misdemeanor convictions are automatically sealed after 10 years with no new misdemeanor or felony convictions. Other types of cases you can petition, you can ask the court by filing paperwork to seal them, even if they wouldn't be sealed automatically. So, for example, only second and third degree misdemeanors or ungraded misdemeanors are ever going to be sealed automatically. Many, although not all, first degree misdemeanors can be sealed by filing paperwork and getting a judge to sign off on it. But that's something you would need to do yourself. If you aren't sure if your misdemeanor conviction is a first degree, which is the most serious, or a second or a third degree, again, you generally can check that on the Pennsylvania State Court's website, run by the Administrative Office of Pennsylvania Courts. And if you aren't sure, contact Legal Aid's intake department and we'll see if we can help you out. There are, like I said, sometimes you can seal the misdemeanor conviction after 10 years, although I want to warn you that if you have multiple misdemeanor convictions, especially if there are multiple first-degree misdemeanor convictions, or if you have felony convictions, sometimes that increases the amount of time you need to wait from 10 years, which is the baseline to seal misdemeanor convictions, up to 15 years, or sometimes even up to 20 years. It really just varies based on the number of convictions and how recent they are. So we need to look individually at each person's record to figure that out. Another requirement to ask the court to seal the record is that you can't owe any money on the case that you're trying to have sealed. So if you aren't sure if you owe money on the case, that information is available on the state court website, or you can call the clerk of courts from the county where the record is from, and they should be able to figure that out for you. You can also make payments on the Administrative Office of Pennsylvania Court's website, or directly at the courthouse, or by mailing in payment generally to the courthouse. If you owe money on other cases that you are not trying to have sealed, that's fine. It's just the one case or the cases that you specifically want sealed that you can't owe any money on. I should say, in certain limited instances, Legal Aid is able to help clients seek to waive some, if not all, of their financial obligations to the court. If that's something you're interested in, if you've got an overwhelming amount of debt that you just really don't think you're going to be able to pay off, and if the record is otherwise eligible to be sealed or expunged, so it's a misdemeanor conviction that's already more than 10 years old, you haven't had any new misdemeanor or felony convictions during that time, by all means contact Legal Aid and we'll see if we can help you ask the court to waive that debt for you. Okay, other things that would prevent you from sealing your record: if someone has ever been convicted of a first-degree felony, they cannot ever seal anything else on their record. Now, I should flag that felony convictions themselves are never eligible to be sealed under the law. So this prohibition, the thing where it become an issue is if, let's say, I had a felony conviction, a first-degree felony conviction, perhaps for something like aggravated assault from 1996. And then in 2005, I had a second-degree misdemeanor conviction for retail theft. And if I don't owe any money on that retail theft conviction, it's more than 10 years old. I haven't had any new misdemeanor or felony convictions since then. I would be eligible to have that record sealed, except that because I had that first degree felony conviction, I am not eligible to seal the later misdemeanor. And that's just in the clean slate law. Okay, other things that would prevent someone from sealing other things on their record. If you've ever been convicted of murder or anything where the maximum possible sentence is more than 20 years incarceration, 20 years in prison. Now, I will say most things that could get you 20 years are already first-degree felonies, and it's a little easier to figure out if what you were convicted of was a first-degree felony than to try and do the research to figure out not what your sentence was, but what the most harsh sentence you could have gotten. I will just tell you that in all of my research, the only conviction that I found that could get you more than 20 years incarceration that wasn't also a first degree felony was if you were convicted of not just one, but two felonies for possession with intent to distribute. That would get you a 20 or could get you a 20-year sentence. And if you have those two possession with intent convictions, then you wouldn't be able to seal misdemeanor cases elsewhere on your record. Okay. As you can see, this law gets pretty complicated. Again, I invite you to contact intake if you've got any questions. I will show you briefly that intake contact information one more time before we start to talk about pardons. The pardon process is lengthy, but it offers exceptional relief. The pardon process is extremely open, so the clean slate law and the expungement law are very clear about who is eligible and who is not based on the type of record that they have, whereas the pardon process is really very open. So anyone is eligible to apply for a pardon. There is an application form that's available for free on the Board of Pardons website. You can download it at any time. It asks you to gather some court records to document to the Board of Pardons what the case was. Gives you an opportunity to explain in your own words what happened, what was your involvement with the case. And then it gives you a chance to give a personal statement to talk about what's going on in your life now compared to what was going on in your life at the time of the record, how having this record 5, 10, 20, 30 years later is still, affecting your life, and what it is exactly that you'd like to be able to do that you can't. You can also talk about any ways in which you're giving back to the community, whether that's raising your family or doing community service or any other contributions. You can also submit additional supplemental documentation. So if you've got degrees or certificates or diplomas or letters of recommendation or employee of the month certificates, anything like that you can and should include in your pardon application. The pardon application it's free to apply. They've done a lot just in the last year and a half to make the pardon application easier. They've done away with many requirements for various background checks that used to be expensive and time intensive to get. So I'm really encouraging many, many people to apply for a pardon. Even though it's a long process, people may feel like, what's the point of applying now? I need a job now when I know that my pardon might not be granted for a couple of years. And while I'm sympathetic to that, I feel that frustration with my clients every day. While the best time to apply for a pardon might have been 2 or 3 years ago so that your pardon could be granted and you could be working on the expungement now, the second best time to apply for a pardon's got to be today, because the record's not, unfortunately, going to stop being an issue in 2 or 3 years unless you do something now to clear it up and get it out of your way. Again, if you have questions about the pardon process or you want to see if legal aid can help you with it, I invite you to contact our intake department. While anyone is eligible to apply for a pardon at any time, I will tell you that legal aid, we have certain priorities just based around what we think is going to be someone who's most likely to succeed in the pardon process. So if someone has a misdemeanor conviction that they're looking to have pardoned, we usually ask that they have at least 3 to 5 years after that conviction, having completed probation, where they don't have any new arrests, charges, convictions, a completely clear record for at least 3 to 5 years. The reason I say 3 to 5 years is because not all misdemeanor convictions are the same, right? I could have a first-degree misdemeanor, violent conviction for something like simple assault, or I could have a third-degree misdemeanor, which is the lowest type of misdemeanor conviction for writing a bad check. The Board of Pardons doesn't treat those two things equally. And so if you have one of those lower level, nonviolent misdemeanor convictions, maybe you only need to wait 3 years. Whereas if it's a first degree misdemeanor or the underlying facts of what happened just sound particularly serious, or it's a crime of violence, then probably you want to wait closer to 5 years. Again, that's just my recommendation based on my experience. You are absolutely eligible to apply sooner. It's completely your choice. For felony convictions, legal aid has identified that you want to wait at least 8 to 10 years after the conviction. And again, that's the range is similar. Is it a third degree, which is the lower type of felony, or is it a first degree felony? Is it a crime of violence or not? And then some of the variability is also based on you and your story, right? During that time since the record, you may have completely transformed your life. You may have gotten advanced degrees. You may be, raising foster children or, volunteering, doing some sort of amazing community work. And that is going to be persuasive to the Board of Pardons. Whereas, someone who doesn't have those things might need to demonstrate that they're a good pardon candidate by having more time where they haven't had any new convictions. Okay, so in terms of the process, once you get the application together, along with, writing those statements and getting together what other supplemental materials you want, your letters of support, your diplomas and certificates, you mail all that into the Board of Pardons. Sometimes they keep promising an online application submission process, so you can check their website to see if that's available. Once you submit the application, it may be a couple of months before you get a review, and they tell you whether your application's been accepted or rejected for some reason. So it could be rejected because you didn't fill out the paperwork right, or because you were missing some of the court documents you needed to give them. You can, of course, always fix that and resubmit it. If your application is accepted, then it will eventually be reviewed. And if it is worthy of further consideration, you may be contacted by a state parole agent who's going to talk to you, interview you, sometimes in person, sometimes, now because of social distancing, they're doing that over the phone. They'll give you a list of questions they're going to ask you ahead of time, so there aren't any big surprises and you can prepare. And then after that interview, then the parole officer will write up a report and give that to the Board of Pardons. And the members of the Board of Pardons decide, after considering your application and supplemental materials, as well as the parole agent's report, whether or not to give you a hearing. If you are given a hearing, that's great, because it means you've made it to, almost the final step, and many people don't get hearings. So although it means, unfortunately, a trip to Harrisburg for the hearing, it's actually really great news, because it means you've made it through many, many levels of culling of applicants who they decide don't make it to that stage. If you get a hearing before the Board of Pardons, generally at this point you have to go in person. The board, sometimes they have questions to ask you. Sometimes they'll say, based on what you've submitted, that things look good. If they say they don't have questions for you, in my experience, that's always been a good sign. If they have questions for you, it might be things like, talking about any history of drug or alcohol use, especially if the record is related to that. If it was a crime involving violence, they might talk to you about perhaps, any anger management classes or how you've been handling that, just to sort of try and put their minds at ease that you're not going to have similar issues in the future. If there's a victim, they're also notified of the hearing, and they have an opportunity to appear at the hearing if they so choose. Overwhelmingly, no one comes, but it is a possibility. At the most recent time I attended a Board of Pardons hearings, of the, I think, 60 or 70 people who had hearings that day, victims came for 2 of the cases. So not impossible, but not very common. You can certainly imagine, based on what your record was, whether there even was a victim, or whether you think they might be at all motivated or interested to come. At the end of the hearings that same day, the board will confer privately, and then that same day, usually in the afternoon, they come out publicly and they give a public vote to see who they're recommending for a pardon to the governor. There are 5 members of the Board of Pardons, and you have to have at least 3 people vote in support of the pardon for it to get the recommendation to the governor. If you get the recommendation to the governor, that's an excellent sign, but you do have to wait for the governor to, make a final decision before your record could be pardoned. And then at that point, you get your pardon decree, and that is what you would use to be able to ask the court to expunge the record so that it's gone entirely. Okay. So that is the pardon process. Before I leave you, I do want to take a few minutes to talk about employment discrimination protections for folks. So I'm going to say generally, there is a federal law that has been interpreted by the EEOC to say that employers cannot have blanket policies refusing to hire people with records without doing a detailed analysis of what the record is.